apart from your records, which show that you were doing certain menial jobs, you were a poor man before you came back to Nigeria to be governor. Tell us, if this is not Nigerian government money, where you got this money from. And they applied the law. It's called Anwa against R, the rule in Anwa against Regina, or DPP, which says the onus is on you now to explain, and it's backed, I think, by Section 22 of the Proceeds of Crime Act in the UK. And so in Nigeria here, you were required to prove, like Chinelo rightly pointed out, the predicate offense. Is it from drugs? Is it from Yahoo? Is it from, what is the unlawful activity that you partook in it? The EFCC that was prosecuting could not establish the predicate offense in Nigeria. And what do you expect the judge to do? On sentiments, convict him? He was therefore discharged. Had he sat down in Nigeria instead of going on a junket to Dubai, he would not have been arrested on an international arrest warrant. But his enemies, perceiving that he had plans to contest presidential election in Nigeria, ensured that they set the traps in advance for him. So as soon as he got to Dubai, relaxing, they pounced on him and took him to the UK. Now in the UK, he was asked, we are charging you under the rule in hour. I participated with all the UK council. They said this is the best way out. Which advice they gave him is not to defend himself. Is to maintain silence, to remain silent, which will be like a plea of guilty. They're not saying you stole money. They're only saying explain. If you cannot explain, you are then guilty of the offenses that you are charged. And he kept mute. And that is how they obtained. But by keeping mute, instead of spending 26 or 27 years in prison, if he had defended himself and wasted the time of court, he merely spent about 5-6 years and he was allowed to come back to Nigeria. So that is the true story. So the point now here, with that background experience of what happened to him, his colleagues in the National Assembly, ministers, and other high-ranking politically exposed persons, saw it as the end of their natural and political lives if Nigeria has a law that can expose you to explaining your unexplained wealth. How will some people explain 3 or 4 private jets traceable to them, yachts, even though they may call it presidential yacht or naval yacht, their harem of wives and houses that they have built? Now, how will they explain that? The option is to provide a civil avenue and a criminal avenue. So instead of taking them to court, where they are the ones, because the burden of proof will then automatically shift to them in a criminal matter, they can be charged for civil forfeiture, where all sorts of negotiations. I have 20 houses, I will declare 5, give the state 3, and they leave me with 2, and I'll go back and enjoy my 17 properties. So, Chinelo, it is not for the disadvantage of the poor man. It is for the benefit of politically exposed persons. That is why you have a criminal route. The day the noise-making lawyer annoys them, they will charge him with the criminal aspect of Proceeds of Crime Act. Oh, you are holding money for your client, and we think the money in your account, just like they tried to do it with Zekome, challenging why should he earn 75 million, that who does that? But compared to what they they spend in a day, and on very unaltruistic things, that is peanuts. So that is the purpose. It just goes to confirm why he said that the National Assembly knows what it's doing. And when we take our eyes off the ball, they have deliberately put these provisions. But the truth is, most of these provisions are unconstitutional, and therefore the ball is in the court of lawyers to challenge it. If you are expecting anybody to come down, any angel to come down from heaven to come and prosecute your battles, you will discover that you're on your own. Thank you, Mr. Chairman.
That was massive. Another more heavy round of applause, please. Good. I think we should first of all take the response of Mr. Benedict Daudu, if he's still with us on Zoom.
Technical.
Can we do that for now, or we go to others first?
I'm still here. I don't know if I can be heard.
Oh, fine. You are with us. Thanks for keeping with us.
Yes, sir.
Being with us. Yes. Did you hear the question? We would like to hear your response.
Yes, as regards to the gentleman's question concerning the boundaries that we as lawyers have to be mindful of in not overstepping when we use artificial intelligence, it's first to understand that the use of AI is actually, it's a tool. It's not something that one should see as his bread and butter, and it's a skill set that should be added to whatever other skill sets we as legal professionals must exude. And in doing so, there are several boundaries. One is the issue of confidentiality. When certain use of AI is required, providing or submitting to these softwares some form of information about your client, you are in fact rendering yourself susceptible to the legal disciplinary committee, because once it is found out that you have issued certain information that should not have been in use, then you can actually run foul of the RPC. And then this also means that we especially since there have been interventions that have shown that we have to put and update the various rules that we have in line with recent developments such as artificial intelligence. So too, the RPC must actually address issues of confidentiality. There should also be, in drafting certain agreements, be an inclusion of a segment in the contract that attests, sort of like an attestation clause, that AI has not been used in the draft of this in the draft of this agreement, because like it is a tool and does not really reflect the innate abilities of a lawyer. Another which I think should be mentioned is that there is a bias that artificial intelligence has. It is actually one that information it gets, the information that it is presented with. So lawyers have to be very mindful of those possible failings of artificial intelligence, because it mimics what is present and what is already stored. So if what is stored has several biases, then you will only provide your clients or anything with information. So that's just my 2 cents on that. Thank you.
Thank you so much, too. We appreciate. I think the best thing we can do now is for the lead presenter to respond. Other than him, I don't think there's other. Chinelo, you are passing the ball to her.
Thank you, Mr. Chairman. I think that the question, the moderator, who is also chairman of a branch in Abuja here, and the question asked but on the same as far as money laundering is concerned. If you understand our reasoning in saying that certain sections of that law, as far as confidentiality and privilege is concerned, the authorities are saying, first of all, there is section 192 of the Evidence Act, which makes it mandatory as to issues of confidentiality and confidentiality between lawyer and client. Therefore, before you take it away, go and repeal section 192. That judgment was not appealed. Nothing has happened to that judgment. What they now did subsequently was to repeat the law that has already been pronounced upon by the Superior Courts in this 2022 Act. And so it has not changed anything. The 2011 Act is saying lawyers must disclose. Two other judgments, or three, if we add the one Chinelo mentioned, are saying lawyers are not parts of that group that you demand must disclose. You now came back and repeated the same law. It doesn't change anything. Number two, as to what Mr. DAUDU Paul said, yes, there are treaties, but assuming the treaties are domesticated in Nigeria, the moment they are domesticated, they become part of Nigerian laws, and so must follow the already existing law. If they are inconsistent like these ones are, you cannot say we are duty bound to join other countries and follow what they are doing. We should be governed by our own laws. So, assuming any of them were here, it would have made an interesting conversation among us here for them to justify that on the basis of the fact that we subscribe to a treaty, which I don't know whether we have domesticated or not, but if we have domesticated it, it's part of our Nigerian law. And being part of our Nigerian legal system is that section 11.4 and 30, which we have now said is invalid by reason of these judgments. I hope I have answered the two. If there's any other thing, I think Chinelo, who is more current on, can add to it. Thank you.
Thank you so much. Well, no, he has said he's not going to. Yes, it's been a very rewarding session, and as I promised at the beginning that I'm not going to summarize, I'll just say my own, I'll just say what is on my mind on this topic. I am of the firm viewpoint that the legal profession, which constitutes or which involves both the bar and the bench, has been aptly described as the glorious vanguard and dynamic propulsion of the rule of law. The catch at this point is that both the bar and the bench have the dire need to perform their assigned roles in a manner that is above board. Just like Caesar's wife, they are expected to be above suspicion. Hence, with a bold and courageous bench, aided by a dynamic and vibrant bar, excesses of agencies and to a great extent will be curbed, curtailed, and eradicated, regardless of their behemoth and tormenting nature, and arbitrary dispositions of such agencies. In fact and indeed, the fact remains that if you are made to watch over others, then the need for you to be placed under scrutiny too becomes an imperative duty. At the end of the day, we should all stand for what is right, even if it means that you will be standing alone. You don't have to go along to get along. In order to get along, always remember the son and daughter of you are. I once again thank the Rule of Law Development Foundation, the coordinator and the convener of this outing, the organizers, for doing a yeoman's job and agitating people's mind and send their thinking, let them put on their thinking caps and just not be passive, that they should continue to be active. Thank you for your patience and your contribution. A healthy round of applause for all of us. Thank you so much.
Thank you very much, my Lord. Honorable Justice Oredola JCA retired. Let's give them a resounding round of applause. This is what you call a front burner issue, which is an intersection between legal practice. In fact, as the coordinator of Rule of Law Foundation has said, we are on the verge of extinction. And there's need for us not to allow AI and rules of professional conduct and laws where we have a very dynamic constitution that is there for us to leverage on, and it's very clear. The constitution sometimes will lambast this constitution, but sometimes it's actually there for our benefit. So I want to thank all the resource persons for giving us erudite presentations. We thank particularly the lead speaker, DCA Wellum, Senior Advocate of Nigeria, for giving us that well-researched paper. Please, let's give him a round of applause. You have shown mastery time and time again in this issue, particularly of proceeds of crime. And I'm sure most of your points will form the communique point. The rapporteurs are there, capturing every single thing you have said, sir. And we promise that those that need to hear, thank God, God has blessed us at the Rule of Law Foundation. Many of us who are now beginning to be in areas where we can effect change. And I think with some of the persons we even have in this conference, I'm sure most of what we have said will reach those that need to hear it. I also want to congratulate and thank Benedict Daudu, the SSA Legal and Multilateral Cooperation, to the Honorable Minister. Thank you for staying with us online. You have also contributed immensely to the topic on ground. Please let us also give him a round of applause. And to our contributors, Chinelo and David, who was unavoidably absent. He had to leave, and he took permission from the chairman before he did. We thank all of you for also giving your own unique perspective to the already very rich presentations. So this brings an end to day 4. Just by way of housekeeping, please, the books are still available. The 2 books that were launched are still available. Don't forget, this price is only available this week. After this, you will resort to market forces and capitalism, because we have to recruit. Because I know the author spent a lot of time writing this book, and it's just a contribution, it's a token sum. If this book is sold at W.A. Smith, you know how much you pay for it. So please try and get Daudu's Miscellany. Is 50,000, and there's also the directions of the LPDC. Please don't leave this conference without getting at least a copy. And the 10 young lawyers will be announced at tomorrow's meeting. There is 10 young lawyers. We're asked to give some copies to 10 young lawyers, so that were early to the meeting, to the program on those that attended on Monday. That was the announcement. So please, we'll announce. And those that are yet to get your books, I'm sure they will be signed and ready for you by tomorrow. If not, we'll dispatch to you and it will get right to your doorstep. So tomorrow we have a very light session. We know it is Friday. We know that our brethren who are Muslim need to go for prayers. So we are going to have only one session tomorrow. And to make the best of this session, let's try and come by 9 o'clock, where we are now dealing with issues concerning violence against persons. We are focusing especially on protection of children, women, young persons, and other vulnerable groups. And it's a very, very, very important topic. And we have speakers like Izoma, Izora, Chisom, and I heard another speaker also be coming. And then we also have Emmanuel Onitu, who was in this panel, will be there. NAPTIP also will send representatives. So let us be there so that we can finish as early as 12 o'clock and close the conference. So on behalf of the Rule of Law Foundation, once more, I want to appreciate the audience for participating adequately in this program. You have been listening attentively, and I'm sure we have all, as an audience, really benefited from the caliber of resource persons that we have seen here. We want to appreciate the coordinator of the foundation for giving us this opportunity to cross-fertilize and exchange ideas. We'll continue tomorrow, and without much ado, God bless us all. Please, let us make it a day tomorrow. God bless us all. We'll now take group photographs. The panelists are now invited to take group photographs with the chairman of session. So the photographer should position himself. Chinelo, I don't know if there's any other announcement.